I ask whether parties are ready to proceed? Mr. Coper, are you ready to proceed? Yes. So are we still waiting for interpretation? Was that the signal there? Can the interpreters, can you address the issue? It appears that the interpreters have lost power, so we'll just have to suspend for just a moment. We're going to have to, unfortunately, just suspend the proceedings for another few minutes. The English channel of interpretation works. The Spanish language channel does not. There's a power problem. So let's just suspend for a few more minutes. Mr. Reddy, sorry to have you sitting there just for the moment. Okay, it seems as if we're good to go. Okay. Let me just make sure that everyone at the back of the room, headphones are working, interpretation is working, transcription is working. Right. Okay. Mr. Reddy, welcome. You have in front of you a witness declaration. I'd be grateful if you would read that into the record, please.
I solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
Thank you very much. I think you should have in front of you copies of your witness statements.
I do.
Mr. Coper.
Thank you, Mr. President. And just for the purpose, since this is our first witness and we are being webcast, I'll just record that pursuant to the procedural order, it's not in order for me to ask questions in chief in the normal trial sense, but rather to ask a limited number of introductory questions, and then we'll primarily be dealing with cross-examination. Mr. Reddy, you have 3 witness statements in this proceeding, correct?
Correct.
And you wish to make some minor corrections to each of them relating to dates. So if you could turn to witness statement 1. You had a change to paragraphs 12 and 16 you wanted to make?
That is correct. We negotiated the sale of the Playa Grande properties in 2004, but they did not close until early February 2005.
Okay, and on witness statement number 2, at paragraph 5, is there a similar correction?
Correct. Same correction. The sale was negotiated in 2004, didn't close till February 2005.
Okay. And in paragraph 42 of the second witness statement,
On the South Playa Grande lots, it says we purchased them in December 2006. They actually closed in May 2006.
and turning to your third witness statement in paragraph 22, you had a correction there.
It calculates a 16-month period from October 2011 to February 2012, and that is a 4-month period.
No, thank you. So just by way of general statement, your position with Spence Company is what?
Chief Financial Officer.
Okay. And when did you first become involved in conducting due diligence in Costa Rica?
2004.
How did that come about?
Bob Spence asked me to go. He had purchased a condo. He'd purchased some land in Ventanas. Both of them had appreciated rapidly, and so he thought it would also be a good business opportunity for us to look at development possibilities down there.
And before you get to the negotiation of the purchase, describe the due diligence you performed while evaluating the investments in Costa Rica.
I flew down to Costa Rica. I looked at properties in the Guanacaste region from Playas del Coco area in the north, through Flamingo, through Tamarindo, through Hacienda Pinilla, Playa Avellanas. I visited with almost every real estate office I could find. I went to San Jose to interview an attorney that was recommended to me, and I also went to Stewart Title in San Jose.
And with respect to the particular investment opportunity in issue in these proceedings, what did you learn through your due diligence?
The properties in Playa Grande, Playa Ventanas are very special properties. So less than 5% of the coastline of Costa Rica is privately titled. The remaining 95% is concession properties. So those 5% are just rare for that alone. When you combine, it's a white sand beach, accessible by road. A lot of this coastline is not accessible by road. Has water from a municipal water system, has electricity from municipal electricity, and then is one of the best surfing sites in, I hear, all of the world. So it had just many features going for it that made it extremely rare and valuable to us.
What was your view of the impact of a concession rather than a free title on potential purchasers?
American buyers are used to title property, and we thought our purchasers would be American buyers. They're not used to concession property and property that you could potentially lose. So Mexico had some concession property. I mean, a lot of American buyers struggled to keep their titles, had their titles taken away, so they're just not comfortable buying concession property. So we really stayed and focused on privately titled properties, which are very rare in Costa Rica.
And what type of buyers in general were you looking to resell to in relation to the properties?
We thought our customers would be American with more money, looking for the paradise retirement spot. So a tropical environment, warm water, white sand beach, surfing.
Now, with respect to the Las Balas National Park, what did you learn about the national park in the context of in the course of your due diligence?
There was a project to expand the park at the time in front of the legislature. That project did not pass. I'd heard Costa Rica runs a large budget deficit, like many countries do. Really didn't have the money to fund an expansion of the park. I learned the history of the park, so the 1991 decree, where there was a park inland. It was told to me the 1995 park law superseded that decree and made it into law, and when that change was made, that the park was seaward and not inland, and so all of our properties were privately titled properties up to the 50-meter line.
And in the course of that, did you review the property surveys and obtain professional advice?
Yes, I did. I reviewed each of the surveys, as did our attorney, and we got title policies from Stewart Title.
Now, could you just outline in general terms the development plan to the extent that you progressed to that stage?
We had different properties with different plans, but in the Playa Grande properties, we developed the area. So there was a dirt road, heavily rutted. We paved it so it was nice and smooth, gave us easier access. We fixed water lines so that water is precious in California as well as Costa Rica. We put in fire hydrants in case there was a fire. It doesn't rain there for 6 months, so fire hazard is high. We fixed drainage issues. They have water accumulation, gets mosquitoes, gets dengue. So we tried to take care of that. We cleared the vegetation so you could see the property. We marked all the corners of a property so that you could see exactly what you were buying.
And in terms of proceeding to building, what was necessary in your understanding to obtain a building permit?
You need to get a water availability letter from the local ASADA, water agency. You need to get an environmental viability through Satana. And in this area, you needed to get a stamp from Menai that would tell you whether you're inside or outside of the park.
Did you proceed to obtain building permits?
Yes, we did. We applied for 4 building permits. We received all 4.
And what happened with respect to your development after that? Take us later into the course of the history.
Soon, so we cleared all the lots. We put markers up to define all the boundaries. We labeled them so people knew exactly what they were looking at. We had a price list. We had a real estate agent selling them for us. Then soon thereafter, Satana issued a suspension of environmental viabilities, which is suspension of building permits. And so that kind of slowed things down after that point in time. Later on, Sonara put in another suspension of viability, environmental viabilities. Couldn't build, in 2009. So we've just had a lot of roadblocks thrown in front of us that's inhibited the development of the property. On South Playa Grande, those properties, we bought those. We submitted a development plan to create 44 lots on that property. We went to get a stamp from Menai so they could say which ones were in the park and which ones were out of the park. Menai refused to stamp our development plan. We had to sue. That lawsuit took a few years. We finally won that lawsuit that said they had to stamp it, whether it was inside or outside the park, whatever their opinion was, but we won negligible damages. At the end of that development plan, the rules had changed as to what a development plan had to include, and our lot sizes had to change, and so we would have to resubmit a new development plan to develop South Playa Grande.
Okay. Now, with respect to the presence or the locality of these properties adjacent to the marine park, what was your thinking at the time about how that played into your development plans and your prospects for sale to American buyers?
It's an attractive bonus. Americans like national parks. They want to be someplace that's desirable and clean. Everybody is supportive of the turtles. So the park only extended to the 50-meter line, only the sand and out to sea. The park did not extend inland.
Now, with respect to the some of the facts that are in the record, and I'm going to have to skip to only a few of them, do you recall hearing about the Puerto Rican Supreme Court decision in December of 2008?
What?
The Puerto Rican Supreme Court decision?
Puerto Rican?
I'm sorry, Constitutional Court.
Constitutional Court, okay. Yes, I did hear about the decision in 2008.
And what was your reaction to that and understanding of what was going to happen?
That the court ordered Menai to immediately begin expropriating properties. So the process of expropriation hadn't started on many of our lots. I believe we had 8 lots that had not even the first notice of public interest, never mind a decree of expropriation. The Ventana lots, which was, I'm going to say, is another 9 lots. There was a notice of public interest that was not followed up by a decree of expropriation. So on very few lots had anything moved, but I expected with that court order that starting in January 9, the Costa Rican government would finally begin an expropriation process.
Now, changing direction, were you involved in the discussions about a mixed refuge later in the period?
I was involved in a mixed refuge discussion starting from 2006, and it continued into 2012 and 13.
Okay. And what eventually happened to those discussions?
They did not result in anything. We had a bill in front of the legislature that President Arias had promised to support. We thought was going to get passed very late in his administration. At the last minute, he did not pass it. His protege, Laura Chinchilla, took office immediately after him. We thought that she would pass it, being his protege. There's a bunch of stuff happens early with the new administration that our project of law wasn't at the top of that list, so we had to wait for some time for it to come back up, but it never came back before the legislature. I think it just died in committee.
And so overall, Mr. Reddy, could you just express to the tribunal what has been your experience with the expropriation process in Costa Rica in general terms?
It's just extremely frustrating. It takes an extremely long time. We're not being offered fair and adequate compensation, and the delays have just been ongoing and exist to this day. We expect much more prompt justice. So.
Do you continue to own titles?
We do continue to own titles. We continue to pay property taxes every year, and we continue to maintain the properties we still have possession of. So effectively, nothing has changed, other than not being able to build on those properties.
Those are my questions in chief.
Thank you, Mr. Cooper. Mr. Alexandrov.
Thank you, Mr. President. Mr. President, as a preliminary point before I turn to the witness, some of the evidence adduced in direct was not in the three witness statements. We're not objecting to that because you've admonished us that we need to be flexible and we don't object to the admissibility of the evidence just adduced. I want to make that point because we should be allowed in our directs, if necessary, the same flexibility. Good morning, Mr. Reddy.
Good morning.
Mr. Reddy, we will be distributing a binder with documents, and I'll be referring to some of those documents during your cross-examination. So give us a second to do that.
Okay.
Mr. Reddy, so behind tabs 1, 2, and 3 are your three witness statements. And I ask you to turn to tab 1, your first witness statement, paragraph 9. The fifth line, you see at the end of the fifth line a sentence beginning with expropriating. Do you see that?
Okay.
Could you read into the record the rest of the paragraph beginning with expropriating undeveloped property?
Expropriating undeveloped property would provide little to no help to endangered turtles, and thus expropriating valuable white sand, great surfing, beachfront property would make no sense, would make no sense as there's no benefit to the endangered turtles. Do you want me to continue?
Yes, please, to the end of the paragraph.
Okay. The turtles nest on a sandy beach where they're able to dig. They do not nest on the private properties that have bushes and tree roots where the turtles cannot dig. Expropriating the private property would not increase the turtle nesting grounds, but solely provide an additional buffer zone of limited benefit. For business people such as ourselves, for the government to spend hundreds of millions of dollars to expropriate undeveloped land that would not substantially benefit the endangered turtles made no sense whatsoever. Thus, we always expected that we would eventually be able to responsibly develop and sell these beautiful and rare properties.
Is it fair to summarize your testimony, Mr. Reddy, that you believe a buffer zone around the nesting grounds would make no sense?
No, it would not be fair.
Well, aren't you saying here that a buffer zone makes no sense?
I said it was of limited benefit. I'm sorry, could you speak into your microphone, please? Sure. It's, I said it was of limited benefit.
Well, you say expropriating valuable property would make no sense and there was no benefit to the endangered turtles.
I said of limited benefit in those sentences. I can point it out to you if you like.
Well, I'm reading a sentence that says expropriating undeveloped property would provide little to no help. And the sentence ends that expropriating valuable white sand, great surfing beachfront property would make no sense, and as there was no benefit to the endangered turtles. These are your words.
And let me restate those for you. I say limited to no benefit, so limited benefit is included in that answer. If you read the sentence, it's expropriating the property would not increase the turtle nest grounds, but solely provide an additional buffer zone of limited benefit. And so I've responded to limited benefit multiple times here.
Right. So you're saying limited to no benefit.
Correct.
And what qualifies you to make that statement, Mr. Reddy? Are you a scientist?
I'm not a scientist.
What is the basis of your understanding that there will be little to no benefit to the turtles from the buffer zone?
I read articles. I'm interested in this area, so anything that's public information.
Okay, so this statement is based on public information.
Based on information I've read, yes.
Okay. Could you turn to your second witness statement, which is behind tab 2, paragraph 4?
Okay.
You say there, Spence Co. is an experienced property developer with over 30 years of real estate development experience and involvement in more than 50 real estate development projects. That's correct?
That's correct.
That's extensive, isn't it?
That is extensive.
And then you continue, before making such a large investment in Costa Rica, which was a new market for us, I performed due diligence with respect to the properties that were to be purchased.
That is correct.
And in fact, you testified on direct about the due diligence that you performed, correct?
Correct.
Okay. Well, let's go over the dates of the purchase of the property because you corrected some of the statements you had made, so I want to make sure we have those dates correct. With respect to lots V, 61, A, B, and C, as I understand your testimony, they were purchased on February 4, 2005?
Correct.
Okay. C71, also February 4, 2005?
Correct.
A39, February 22, 2005?
Correct.
A40, February 22, 2005?
Correct.
C96, June 28, 2005?
Correct. It was part of a contract at the same time, February 4, but closed at a later date.
Well, let me make sure.
So it closed in June. The contract was dated February.
Okay, well, if you look at your first witness statement, paragraph 22, please. On June 28, 2005, Spence Co. acquired lot C96 on Playa Grande. So, is this the date or is this not the date?
Could you refer me to that paragraph again?
I'm sorry, paragraph 22 of your first witness statement, and I just read it into the record. I'll do it again. On 28 June 2005, Spence Co. acquired lot C96.
That's correct.
It is correct, okay. The SPG lots, SPG 1, 2, and 3, you testified or acquired in December 2006 in your witness statements. You now corrected it to May 2006?
That's correct.
And what was the basis for that correction?
I think it was just a long time ago, so I misremembered the date by a few months. On review of the documents, we saw that it closed in May 2006.
Okay. And what documents did you review to correct your testimony?
Purchase documents for the purchase of that lot.
What, more specifically, what are the purchase documents that you reviewed?
There's a purchase and sale agreement and a title policy.
Have you given those documents to your lawyers?
Have I given those documents to my lawyers?
in this arbitration?
I do not recall giving them the purchase agreements to those properties.
Mr. Reddy, when you testified about the purchase of the SPG lots, you didn't consider it relevant to give your lawyers or to submit to the tribunal the purchase agreements?
If my lawyers requested anything of me, I would provide it.
So they didn't request.
To my knowledge, I don't remember a request for the purchase agreements, no.
And your testimony about the date of the purchase is based on those documents.
Correct.
And I represent to you they are not in the record of this arbitration.
Okay,
Okay. So your current testimony is May 2006.
that's correct.
Do you recall the price of the purchase of the SPG 1, 2, and 3 lots? The purchase price?
In an approximate amount, yes.
When did you last consult those documents? The purchase documents that you refer to?
I would say a couple months ago.
Well, why didn't you correct your testimony then? If you consulted those documents and you correct the date of the purchase from December 2006 to May 2006, why didn't you correct your testimony several months ago when you discovered the mistake?
As I was reading my witness statement, I checked the dates, I looked at the purchase documents. When I saw the discrepancy, I immediately notified my attorneys.
And that was several months ago,
It was a couple months ago.
a couple of months ago. So you said you remember the purchase price approximately?
Correct.
Could you give those approximate numbers now?
I could.
Could you please? For lots SPG 1?
Doing them individually, a little tougher, but doing them in total, about $3.5 million.
Dollars
Yes,
for all three.
correct.
And that's based on your review of the purchase agreement.
And my memory, yes.
V56. Your testimony is that it was acquired May 11, 2007. Is that correct?
V59.
I'm sorry. Did I misspoke? V59 is what I meant.
Could you restate the question, please?
You've testified that it was acquired on May 11, 2007. Is that correct?
That's correct.
Well, Mr. Reddy, you've testified that the declaration of public interest with respect to Lot A40 was issued on February 1, 2006, correct?
Correct.
After the declaration of public interest for Lot A40 was issued on February 1, 2006, you've acquired all three SPG lots plus V59, correct?
Correct.
So help me understand your due diligence then. You have a declaration of public interest with respect to one of your properties, which says it will be expropriated. It initiates the expropriation process. And after that, you purchase 4 more properties.
That's correct.
And you perform due diligence after the declaration of public interest was issued with respect to A40 before you purchased the 3 SPG lots and the V59 lot?
That's correct. We reviewed the Attorney General's decision with my attorney, and he said it was binding upon Manai, but not anybody else. We knew the history of the 1995 law saying the property was out to sea. No declaration of public interest had been issued on the South Playa Grande lots or V59. So we continued to buy private property outside the park at that time.
Well, you've testified that A40 was also outside of the park, right? That was your belief at the time, correct?
That is correct.
But you received the declaration of public interest with respect to that property.
Correct.
That didn't raise a question in your mind about whether you've done sufficient due diligence with respect to all those properties, and you nevertheless proceeded to purchase 4 other properties, correct?
It raises the question, and I addressed the question with my attorney to say, what do you think of this? He didn't think that ruling would stand in light of the legislative history of the 1995 park law, and that I would still be entitled to full use of the property pursuant to the 1995 law and full fair market value of my property until the time it was expropriated, if it was ever expropriated. Besides the legal side, the real estate market here was just absolutely booming, skyrocketing. And so these properties were growing in value at an exponential pace. We thought we were in early, and so we thought it was still a good investment opportunity for us to buy at that time.
All right, and so to summarize your testimony, all that in spite of the fact that on February 1, 2006, there was a declaration of public interest with respect to A40.
Correct. We investigated it, we did our due diligence on it, and we just didn't find it persuasive. So.
You've testified that the declaration of public interest with respect to SPG 1 was issued on April 17, 2007, correct?
Correct.
And the same with respect to SPG 2?
Correct.
And after that, you proceed to purchase V59, correct?
Correct.
So you will say that the declaration of public interest with respect to SPG 1 and SPG 2 did not affect in any way the due diligence you performed before you acquired V59.
No. Anytime we get a declaration of public interest, we would go back through the same procedure to say, what do we think? Will that ruling stand, or do we think we're outside the park entitled to full fair market value? We thought that the law was plainly said seaward. We were allowed to rely on that law, and that property could be ours in fair market value until such time as the government expropriates it. And the government had already taken 20 plus years and hadn't done it, right? So.
Well, it's Minai that issues the declaration of public interest, right?
Yes.
So at least before acquiring all those other properties, you knew that Minai had taken a position by issuing the declaration of public interest that the properties were inside of the park, correct or not?
That is correct.
You knew that they had taken that position.
That is correct.
Okay. Could I ask you to turn to your first witness statement, paragraph 29?
I'm there.
Could you read that into the record, please?
In about 2005, Satana started refusing to review environmental impact assessments for any properties within 75 meters of the inalienable zone. They also refused to review assessments for properties within 500 meters until an environmental study was performed. I then started hearing about the government having issued notices of expropriations for some of the lots within 75 meters of the inalienable zone.
Thank you. So with that knowledge, Mr. Reddy, you proceeded to acquire properties SPG 1, 2, 3, and V59, correct?
Correct.
Let me ask you to turn to your second witness statement behind tab 2, paragraph 36. You see on page 8 the carryover of that paragraph.
Page 7 to page 8, yes.
Yeah, I want to ask you a question about a statement on page 8, beginning on the 4th line, which says, and I'm reading it into the record, I became aware of the Attorney General's report on or around January or February 2006. Do you see that?
Yes.
You confirm that testimony?
Yes.
Well, let me point you to that document. It's behind tab 11. And I'm not going to ask, we have the English first and then the Spanish. You can consult whichever, but I'm asking you to turn to the last page, whether you want the English or the Spanish. There is a Roman 3 that says conclusion. That's the very end of the document.
Conclusions.
Roman 3 conclusions, the very last paragraph, or 2 paragraphs, if you will, above the signature. I think you're not there yet.
I don't I have a.
Just go to the very end of the document, please. Yes.
Okay, I got it now.
Yes.
Okay, what would you like?
I'd like to draw your attention to the fact that the conclusion of the Procuraduria opinion, which you refer to as the Attorney General opinion, is that the park runs on land at a distance of 125 meters from the normal high tide. Do you see that conclusion?
Yes, I do.
And that's what you've testified in paragraph 36 of your second witness statement you became aware of in January or February 2006, correct?
Correct.
And you bought the SPG properties, the 3 properties, and V59 after you became aware of that.
Correct.
And when you performed due diligence with respect to those 4 purchases, the views of the Procuraduria that the park extended 125 meters inland did not play a role, correct?
No, it played a role, but we did our analysis to believe that this opinion would not stand. And we were still comfortable to go through with the purchase, that it would be our private property until such time as it was expropriated. If that ever came to pass. It still hasn't come to pass today.
Right. So to summarize then your testimony, you performed due diligence and you purchased at least 4 properties when, one, you know that MINAE, which is the relevant ministry, has issued declarations of public interest with respect to other properties in so-called buffer zone, and when you know that the Procuraduria has issued a report that says the park extends inland 125 meters. With that knowledge, you purchased 4 additional properties, correct?
Correct. We thought that interpretation was wrong.
I'm sorry, you thought?
The interpretation was incorrect.
Correct. And you thought it wouldn't stand in court?
Legal challenge.
So were you planning at that time to initiate a legal challenge?
We weren't planning to initiate it, but if it was initiated against us, we would defend with that challenge.
Well, what was initiated against you already was an expropriation proceeding with respect to other properties with a declaration of public interest.
But that was all we received, was a declaration of public interest. Everything else happened much later.
Well, yes, but is it correct, Mr. Reddy, that it is the declaration of public interest that initiates the expropriation proceeding?
Yes, it is correct.
It is correct. So you already had an expropriation proceeding with respect to some properties, correct?
Correct. Very initial, yes.
Well, yes, it had been initiated.
Yes.
And so is it then your testimony that you are planning to fight that in court, and in that process you would also defeat the argument that the park extended inland
Yes.
in the context of the other expropriation proceeding?
If we had to, we felt confident our position would stand.
Well, yes. What I don't understand, Mr. Reddy, is when you say if we had to, because it seems to me, given that the expropriation proceedings had already been initiated, you had a choice: either accept the valuation and not fight the expropriation per se, or fight the expropriation in court. So help me understand your testimony if we had to. You already had to because the expropriation proceedings were initiated with respect to some properties. Isn't that correct?
We had an expropriation proceeding with respect to one property, and all we got was a low appraisal. We turned it down, and we were waiting for our day in court to fight.
And isn't it correct that what you fought in court was the amount of the compensation?
We did fight the amount of the compensation.
Did you fight the legality of the expropriation in court?
I think by the time that arose, the Supreme Court had made another decision to say that even if the 1995 law wasn't necessary for expropriation, that they could expropriate pursuant to the 1991 decree.
And that was the December 2008 decision?
I know it was 2008, but I couldn't tell you what the particular date within 2008.
So the short answer to my question is you did not fight in court the legality of the expropriation as such. What you were objecting to in the judicial proceeding was the amount of compensation, correct?
I really can't. I wasn't present at those court proceedings in Costa Rica, so I can't tell you exactly what he fought and what he didn't fight. But I know as soon as that court decision became effective in 2008, that the Supreme Court said they could expropriate pursuant to a 1991 decree, I would no longer fight that it's outside the 1995 law, because the 1991 decree was considered adequate and effective.
Mr. Reddy, you testified that you are the CFO of Spence Co.,
Correct.
and you're saying you did not know what was the object of the judicial proceedings?
Oh, no, I know what the object of the judicial proceedings were, but I was not in attendance at those proceedings to know what was defended, other than I know we try to get our purchase price or our fair value.
Well, if you know what the object of the judicial proceedings were, then I'm asking you, isn't it correct that the judicial proceedings were about the amount of compensation?
Yes, the judicial proceedings are about the amount of compensation.
Could you go to your third witness statement, which is behind tab 3? And I draw your attention to paragraph 12.
I'm there.
What you're saying there is that, quote, building permits were being issued for lots inside the currently designated park boundary right until 2008. And that stopped in 2008, correct?
Building permits inside the park, the 75 meters contested park, did stop until 2008. Other building permits outside the 75 meters continued.
Right. But within the 75-meter strip of land, issuing building permits was no longer
After
an option after
2008.
2008.
Very sorry.
Both of us need to be patient, I apologize. So your testimony is that within the 75 meters, issuing building permits stopped sometime in 2008.
Correct.
And you've testified that you knew that.
Correct.
Okay. Mr. Reddy, I want to go over a couple of registry drawings with you. So if you turn to tab 16, and for the record, this is exhibit C12A. You have the Spanish original behind tab 15, if you want to consult that. Behind tab 16, we have only translated the stamps into English, so you can consult both documents. Just so that you have the complete document in Spanish behind tab 15. This is the registry drawings for lot V59 purchased in 2007, correct?
Tab 16?
I'm sorry, you're asking which tab?
In tab 16, I don't see the registry drawing.
Well, tab 15 is the Spanish document. On tab 16, you will see the translation of the stamps only.
Okay.
I'm sorry for the misunderstanding. So you can consult tab 15 for the document, and behind tab 16 is the translation into English of the stamps. So my first question is, Mr. Reddy, this is the registry drawing for lot V59, correct?
I'm sorry, I don't want to interrupt Mr. Alexandrov, but in my tab 16, I don't see a translation. You may not need it, but I'm not able to locate the translation you've referred to in tab 16. The witness may well be able to answer under tab 15.
It's a translation just of the stamp.
That's not the document in our binder, but I may have the wrong tab 16. But that's
If that's a mistake, I
We
apologize.
have a translation of Exhibit C-12B under our tab 16. I don't know what the witness is looking at. I'm just trying to be helpful. I'm sorry to interrupt.
Could I ask, Mr. President, my colleague check to make sure there is no error in that binder?
Please do. It looks, in my binder, it looks as if it's the correct one, but please do check.
Have you reviewed the document? So let me repeat the question. Is that the registry drawing for lot V59?
I believe it is.
So this is a map registered in January 2003. And there is a stamp saying that the property is inside the park. Do you see that? You can turn to the English translation if you prefer.
Okay, on page 4, I can see the English translation.
So there is a stamp, and what's the date of the stamp? The Minai. There is a stamp of Minai. What is the date of that stamp?
September 3, 1996.
And it says that the property is outside or inside of the park.
It says the property is located inside the Las Balas National Marine Park according to Executive Decree of 1991.
Okay, so point 1, in 1996, Minai certifies that the property is inside of the park, correct?
Pursuant to a 1991 decree.
We'll get to that point. Let's first start by Minai certifies in 1996 that the property is inside of the park. That's correct, is it?
Correct.
And it says that on the basis of the 1991 decree.
Correct.
Okay? And your argument will be that because it refers to the 91 decree and not the 95 law, in your due diligence that you performed, you disregarded that statement of Minai that the property is inside of the park. Is that your testimony?
I would state my testimony to say pursuant to the 1991 decree, Ventanas is not included in the Las Balas Marine Park. And
I don't think there is a disagreement on that.
Okay.
Do you agree that Playa Ventanas was included in the park with the 1995 law
no.
because of the word seawards?
The word seaward, all legislative history, it's a marine park. There's lots of support to say that park was always meant to be out to sea.
Well, but let's focus on that. When you're focusing on seawards versus inland, but there was no question that the 95 law extended the park north to cover Playa Ventanas, whether seawards or inland.
Correct.
So Playa Ventanas, as a general notion, was included in the park. The question is whether it was towards the sea or towards the land.
Okay.
You agree with that?
I agree with that. My land is outside the park.
Yeah.
Correct.
We understand your testimony. Whether we agree with it is another matter, but I want to take this in baby steps. So point 1, Playa Ventanas was included in the park in 1995. Whether the park extended seawards or inland, Playa Ventana was included, correct?
Correct.
Okay. Second point, the stamp is dated 96 after the 95 law was adopted, correct?
Correct.
And the stamp is of Minai, the relevant ministry.
Correct.
So if you see that document, you know that the Minai takes the position that the property is inside of the park because that's what the stamp says.
Pursuant to a 91 decree.
Yes, so Minai takes the position that the property is inside of the park pursuant to the 1991 decree.
Correct. And that, to me, is an incorrect interpretation.
Well, yes. So you say this is an incorrect interpretation, but you know that this is the interpretation of Minai, correct?
I see that there's a stamp that says that.
Okay, so that's my question. When you see that stamp, whether or not you agree with that interpretation, you know that this is Minai's interpretation, correct?
I see a stamp. I don't know that Minai would try to defend that this land is included in the park pursuant to a 1991 decree. To me, that's an obvious error.
Well, whether Minai would defend it or not, my question, Mr. Reddy, is when you see that document with that stamp, you know, don't you, that in 1996, Minai's interpretation was that the property was inside of the park. Whether you agree or not with that interpretation is irrelevant to my question. My question goes to your knowledge. Did you know that Minai in 1996 took the position that the property was inside of the park?
No. And the reason for that is the 1991 decree I felt was superseded by the 1995 law. And so the 1995 law said the property was seaward. And so I did not know at that time that there existed a dispute as to whether Ventanas was inside the park or outside the park. I had also seen catastro surveys for other Ventanas lots that were stamped to say that those lots were outside the park. And I expected this lot to be identical to those, that it's outside the park.
Well, okay, let's look at some other lots. So let us look at tabs 27 and 28. Again, 27, and for the record, this is Exhibit C20A, is the Spanish document, and 28 is the translation of the stamps in English. And my first question is, this is the registry drawing for lot SPG1, correct?
I believe that's correct.
Okay, well, then you can look at the stamps in Spanish, or I am looking in English because we translated them in a legible way. So let's look at the Minai stamp. What is the date of that stamp?
January 13th, 2003?
2003. And it is correct, isn't it, that the stamp says that the property is located inside of the park?
Pursuant to the 91 decree.
Yes, well, let's...
Correct, pursuant to the 91 decree.
Right. So you agree that the stamp says the property is inside of the park?
Pursuant to the 91 decree.
Well, I'm not trying to avoid that.
But there's two
Mr. Reddy.
different definitions, so I'm trying to get to which definition you're
I've asked you
me the
two
question.
questions, Mr. Reddy, and so I ask you to answer. So question one, is it correct that the stamp says the property is inside of the park? And question two will be, and that's pursuant to the 91 decree. So I ask you to answer both questions, correct or incorrect. So question one, does the stamp say the property is inside of the park?
Yes, it does.
Question two, and it says that on the basis of the 91 decree, correct?
Correct.
Okay. So with respect to that property, which is SPG1, did you understand Minai to take the position at the time with respect to that property, and at the time, this time is 2003, that the property was inside of the park pursuant to the 91 decree?
Could you restate that question for me, please?
I'm not going to restate it, I'm going to repeat it. Did you understand, by looking at this registry drawing, that Minai took the position in January 2003 that the property was inside of the park?
Pursuant to the 1991 decree, yes.
Okay. So in January 2003, you understood that Minai took the position that the property was inside of the park based on the 1991 decree. And you purchased that property when? Again?
2006.
So 3 years before that, you knew Minai had taken that position. Did you have any,
I wouldn't see this stamp until the time I bought it. I didn't see the stamp in 2003.
when did you first see it?
2006?
Before you bought it?
Yes.
So before you bought it, you knew Minai had taken the position on whatever legal basis, Decree 91,
Correct.
that the property was inside of the park.
Correct.
And that was part of your due diligence.
Correct.
And you bought the property nevertheless.
Correct.
Let's go to tab 30 and tab 31. For the record, Exhibit C21A. Again, we have the same situation. We have behind tab 30 the Spanish text and the registry drawing, and behind tab 31, the stamp. So, first question, Mr. Reddy, this is the registry drawing for lot SPG2, correct?
Behind which tab, please?
I'm sorry, behind tab 30 is the document in Spanish. Behind tab 31, we have translated the stamps.
I believe so.
Okay. And then if you look at the stamps, we have a stamp from Minai. This is, I'm now looking at the stamps behind tab 31.
Okay.
So we have a stamp from Minai. Again, that's the relevant ministry, correct?
Correct.
And it's dated January 13, 2003, correct?
Correct.
And it says, to avoid back and forth, it says that the property is inside of the park and it refers to the 91 decree, correct?
Correct.
When did you first see this drawing?
2006?
Before you bought that particular piece of property?
Correct.
So the same question. At the time, you knew, whether you agreed or not, you knew that Minai's interpretation was that the property was inside of the park, correct?
Pursuant to the 1991 decree, which I thought was superseded by 1995 law, so I really, at that time, did not know Minai was disputing this being a park.
I'm sorry.
I thought this stamp had been superseded by subsequent information.
After 2003? You thought the stamp was superseded by information after 2003?
No, by the 1995 law.
Well, but the date of the stamp is 2003. And so how could the stamp, or Minai's interpretation for that matter, be superseded by a 95 law when the stamp was placed in 2003?
The decree, I thought, was superseded by the law, so the decree would not be effective.
We understand your testimony that the decree of 1991 is superseded by the 95 law. My question is what you knew about Minai's interpretation, because Minai has a stamp dated January 2003. Minai certainly knows about the 95 law, correct?
Correct.
You could not think at the time that Minai was ignorant about the 1995 law, correct?
Aware that they're aware of the law, which direction it went, I don't know what their interpretation would be at the time.
Well, in 2003, you know they considered the property inside of the park, don't you?
No.
No?
No, I knew that it was considered inside the park pursuant to a 91 decree. I thought that got superseded in 1995.
Well, but Minai puts a stamp in 2003. So if Minai still believes the property is inside of the park, then Minai must not think that the 91 decree is superseded. You couldn't draw that conclusion in your due diligence?
No.
So is your testimony that because of the advice of your lawyers that the 95 law superseded the 91 decree, this stamp was totally irrelevant to your due diligence?
I don't want to say totally irrelevant to my due diligence, but that it was not effective.
It was not effective.
Correct.
And so help me understand what not effective means, because I'm not talking about the legal effect of the stamp. I'm talking about what you knew at the time. And so What you knew at the time was that Minai thought the property was inside of the park based on the 91 decree, which is what you said numerous times. But you thought that Minai's knowledge and interpretation of the legal situation of the property as inside of the park was erroneous.
Had changed with the adoption of the 1995 law that said the park was out to sea,
When did you believe that change in Minai's position took place?
effective with the 1995 law.
But the stamp is dated 2003, and that's 8 years later. So Minai doesn't seem to have changed its position 8 years after the adoption of the law. Isn't that correct?
If they want to stamp it pursuant to a decree that doesn't have an effect on me, I thought the decree was superseded by the 1995 law. And so I still was buying privately titled property that was not ever going to be part of a park.
So is it your testimony, Mr. Reddy, that in the course of your due diligence, there was no doubt in your mind that your property was outside of the park, even though the registry drawings were stamped as late as 2003 as inside of the park? Is it your testimony that there was no doubt in your mind?
That is correct.
Are you familiar with Mr. Berkowitz's testimony? And in fact, this was discussed yesterday by Dr. Weiler, and you were in the room, that Mr. Berkowitz went as far as addressing a question in 2003 to the minister in charge of Minai. Are you aware of that testimony?
Sorry, was he aware in 2003 or today?
No, today.
I object to putting one witness's testimony about what that witness knew in 2003 to Mr. Reddy. I don't think that's a proper question, Mr. Reddy.
I'm not asking him what Mr. Berkowitz was doing. I'm asking him, he was in the room yesterday, whether he's aware that there is such testimony in the record.
I think you can proceed.
I am aware of his meeting.
So at least one of the claimants had doubts, but your testimony is that you are an experienced real estate developer, you performed thorough due diligence, and it never even crossed your mind, in light of everything that you knew at the time, that your understanding that your property was outside of the park might be incorrect. That never occurred to you.
That would be correct. And at the time, I think they were trying to pass a bill to have the park expanded to make my property some point in the future a part of the park. But at that point in time, it is not part of the park.
When was it that they were trying to adopt a bill that would expand the park to cover your property?
I think they had bills to expand the park anywhere from 2002 to 2006.
And what's the basis of your understanding that they were trying to expand the park to cover your property?
That the park would be extended inland.
What is the document you rely on to make that statement?
Newspaper, internet type articles.
What we've seen in the record is a proposal around that time that the park be extended 1,000 meters inland. We have not seen a bill that says the park should be expanded to cover a 75-meter buffer zone. It talks about 1,000 meters. That's a different expansion, isn't it, Mr. Reddy?
I can't tell you whether it was, I thought there was also 75 meters expansion as well.
75 plus 1,000.
At least the 75, and then an additional buffer zone was, different issues came up at different times. But there was always talk about expanding the park into what would be the property that we bought.
Well, are you saying, Mr. Reddy, that a proposed bill addressed your properties in particular?
All the properties in that area, including mine.
Okay, so there was no bill that addressed your individual properties, correct?
Correct.
Well, I represent to you that we have seen in the record documents that suggest that there was a discussion of whether to extend the buffer zone to 1,000 meters. We haven't seen anything else. Is that consistent with your recollection?
I also remember discussions, I believe, about a 75-meter expansion.
You remember a discussion about an extension to 75 meters?
Correct.
With whom did you have that discussion?
We've had discussions with different real estate agents, Minai offices, newspaper articles.
Well, you remember a discussion that you had or somebody else had?
Myself.
And you had that discussion with whom?
I would say real estate agents.
When?
2005 and 6.
And the discussion was that, what?
They wanted to expand the park.
They, the real estate agents.
The Menai.
So real estate agents told you that Minai wants to extend the park to cover 75 meters.
Correct.
Have you testified about that anywhere in your 3 witness statements?
No,
You didn't think that was relevant?
it wasn't asked of me.
So your testimony now is that real estate agents told you that Minai wanted to extend the park to cover 75 meters, and Minai's position was that before that the park did not extend to cover those 75 meters.
Correct.
That was your understanding in 2005 and 6 of Minai's position?
Correct.
Did you show those real estate agents the stamps on the registry drawings?
I personally didn't show them, but they see them on any property that, that we buy. That particular real estate agent would see those surveys.
And did those real estate agents already know that there was a declaration of public interest with respect to some of your properties within the 75-meter zone?
Those real estate agents wouldn't know of a declaration of public interest until that declaration was issued, which wasn't issued until later 2006.
Well, so your testimony, Mr. Reddy, is that you believed real estate agents who told you about Minai's position. You didn't believe the stamps, and more importantly, you didn't believe the declaration of public interest that initiated the expropriation of your properties within the 75 meters. Is that your testimony?
There's multiple questions there. Can we break those out?
Let me repeat. Your testimony is that Minai's position was the park did not extend to cover 75 meters after the public zone inland, correct?
Correct.
And you base that testimony on discussions with real estate agents, correct?
Amongst others, yes.
Yeah. And that is in spite of declarations of public interest issued with respect to your properties in that 75-meter zone, correct?
On the subsequently purchased properties, yes.
Yes. And in spite of the stamps that we went over, correct?
Correct.
Okay. Well, Mr. Reddy, for completeness sake, I'll show you what I believe is the registry drawing for SPG 3, and you'll find the complete document in Spanish behind tab 33 and the translation of the stamp behind tab 34. So take a look at those documents, 33 and 34. So my first question is, this is the registry drawing for property SPG 3, correct?
Correct.
My second question is, let's look at the stamp together. Again, this is a stamp of Minai, correct?
Correct.
It's dated February 25, 2003, correct?
Correct.
It says the property is inside of the park
Correct.
based on the 91 decree.
Correct.
Same question. Did you understand at the time, February 2003, that Minai took the position that the property was inside of the park based on the 91 decree?
I didn't see the stamp until 2006, but my understanding at that time was that Menai did not consider it part of the park because the 1991 decree was superseded by the 1995 law that created the park out to sea.
Let me correct a little bit the timing. I understand your testimony. You saw this for the first time in 96 before you purchased SPG 3.
2006.
I'm sorry, 2006. I apologize. But when you saw it in 2006, before you purchased the property, did you understand that Minai's position in 2003 was the property was inside of the park based on the 91 decree?
Yes,
Okay.
but not based on the 95 law.
If you allow me 1 minute, Mr. President, just to consult on the matter. Mr. Reddy, if you could turn to tabs 18 and 19. We have the same situation here. Spanish document, a complete document with the registry drawing, and then that's behind tab 18, and behind tab 19 is the translation of the stamp. Do you see that?
I see the
I'm sorry.
survey and the catastro in 19.
So tab 18 first,
18 first.
and that's Exhibit C 13A,
Okay.
which is the registry drawing in Spanish.
I don't have a drawing.
That's behind which tab in your binder?
18.
Okay.
I have a drawing behind 19.
Well, maybe we switched inadvertently, so can you look at the drawing behind 19 and see if that's Exhibit C 13A? If you look at the first page, I'm just trying to establish whether you have the same document. Go to the beginning of the document, please, Mr. Reddy. Does it say Exhibit C 13A?
No, that's what it says in tab 18.
Okay. Can I ask my colleague to check?
Please do.
If we have switched the documents. May I ask the tribunal, do you have behind tab 18 Exhibit C 13A?
I have behind tab 18 exhibit C13A in its Spanish version, and then behind 19 the translations.
Of the stamps, and that's what Mr. Reddy should have. I apologize if he doesn't, and we'll fix that.
Right, so C13A,
Oh, okay. Because here it says C13A right there.
right, so it's the same.
So they have been switched in his binder inadvertently. I apologize. So let's go back. So for the record, Exhibit C13A is a registry drawing, a copy of the original document in Spanish, and then we have attached an English translation of the stamps. And my first question is, can we establish that this is the registry drawing for property V61A?
Yes.
Okay. If we could look at the stamp then. You see a Minae stamp.
I do.
The date is August 14, 2006.
Correct?
And it says the property is located inside the Las Baulas National Marine Park, according to Executive Decree or Law Number 7524. Do you see that?
I do.
Law 7524 is the 1995 Park Law, correct?
Correct.
So this time, in August of 2006, Minae is taking the position that the property is inside of the park based on the decree and on the law. Is that correct?
It says or.
I accept the correction. So Minae is taking the position that the property is inside of the park based on the decree or the law.
Correct.
When did you see first that stamp, Mr. Reddy?
Shortly after the property was registered, but it's after we purchased the property.
And when you saw that stamp, did that cause you to reconsider your view that Minae's interpretation of the boundaries of the park was superseded by the 95 law?
It did not change my view of Minae's interpretation. I would say, pursuant to this, Minae's interpretation was that the property was in the park. But I would disagree with that interpretation.
Well, you may disagree. That's not the point. I take your testimony that you disagree. But when you saw the stamp, and we'll get back to when you saw it, you understood, didn't you, that Minai based its interpretation either on the decree or the law?
Correct.
You understood that?
Correct.
So now, whenever you saw that stamp, you could no longer have thought that Minai's interpretation was incorrect because the law superseded the decree, because Minai now is referring to the law.
So the 1991 decree does not include Ventanas, so that would not be effective to this property.
Okay?
And the 1995 law says seaward. And so Minai may have had an interpretation that this property was in the park, but I did not.
I understand. You did not have that interpretation. You have testified about that. But I'm asking you whether you knew at the time you saw the stamp that Minai had an interpretation that the property was inside of the park, including based on the 95 law.
Yes.
Whether you agree with that or not.
Yes.
Yes. Well, and now let's go back to the question of when you saw the stamp for the first time. When was it that you saw this registry drawing for the first time?
I can't specifically recall when I saw it for the first time.
Can you recall approximately?
It could be any time after it was issued in 2006, could be 2007, could be probably no later than 2007.
2007 is a whole year, so no later than what time in 2007? Early 2007?
I really have no specific recollection of the exact day I saw it.
So could have been late 2006, could have been 2007.
Correct.
When you saw that stamp, did that affect your due diligence in purchasing V59, for example?
Did it affect?
Well-
Yes. We consider it, and but I think we again consider it as an incorrect interpretation.
You consider this to be an incorrect interpretation, but you knew this was the interpretation of Minai at the time.
Yes, on this lot, yes.
We can take another minute.
Please do.
No further questions, Mr. President.
Thank you very much, Mr. Alexandrov. Mr. Koper, have you got any questions in redirect?
Just one question arising. Mr. Reddy, you had a number of stamps on some of the lots that you purchased. All of the stamps my friend put to you were stamps which, as he's indicated, on one reason or another, talk about being outside the park. As part of your due diligence, were there also stamps on the lots you purchased stating explicitly that the lots were outside the park?
We did have catastrophes and surveys that said the lots were outside the park.
No more questions, Mr. President?
Mr. President, I think I need to, there were no documents shown, and I need to probe this further, if you allow me.
Well, let me, in the first instance, invite Mr. Coper on his direct examination to identify the documents, if there are any in the record elicited by your question and answer.
The documents are already in the record with respect to all of the registry stamps. I referred to a number of them in my opening. I don't think there's a factual question about which was stamps or not stamps, but
There is, Mr. President.
I think it's a bit late to resume cross-examination on the stamp issue. My friend studiously avoided any lots in which the stamps did anything other than he indicated. So all I was wanting to establish and re-examine was that there wasn't one form of stamp on the lots.
Mr. President, with all due respect, what counsel is doing is testifying. So either those documents should be put to the witness to see what the stamps say, or testimony by counsel should be ignored. I can testify in response about what those documents say, but I don't think that's the appropriate way to do it.
Thank you, Mr. Alexandrov. I mean, Mr. Coper, you asked a question which elicited a very short answer. I think in the minds of the tribunal, there are questions about what those documents and stamps are. So whether or not these are questions put by counsel for the respondent, there's certainly be a question put by the tribunal. So I would invite you to clarify that point. You presumably asked the question with an anticipation of what the answer would be, so I imagine that you have those.
I wasn't prepared to put specific documents to the witness. Maybe we could just take a brief break, and I'll just find an exemplar.
How long a brief break do you need to find that?
Just 5 minutes, I think, is fine. Yeah.
Well, we'll suspend just very briefly, and I should indicate that the tribunal does also have some questions, Mr. Reddy. So.
And to be clear, I wasn't, notwithstanding my friend's remarks, intending to testify. I was simply saying that we'll rely on the documents that are already in the record. I don't require the witness to testify about it, neither does my friend require him to testify to have it in the evidence.
We appreciate that. I think it would simply, in the minds of the tribunal, would like clarity on the point that you've just raised.
President, may I ask that this not be counted against our time?
You can be confident of that. Mr. Coper.
I'm sorry, Mr. President, maybe I'll withdraw the last question. I have a number of stamps, but we don't have ready translations, and we'll have to deal with that in argument.
Okay, thank you very much. The members of the tribunal, Mr. Reddy, do have a number of questions that we'd like to put to you. Mr. Cantor, let me turn to you first.
Thank you, Mr. President, and Mr. Reddy, thank you. My name is Mark Cantor, and I'm one of the arbitrators. Appreciate you taking your time to testify here. Could I ask you to turn to your second witness statement, paragraphs 46, 45, and 46, and 47. Do I correctly understand that there are 9 properties in the administrative stage for Spence and Spence Co. And then there are 8 properties that have gone into the judicial phase? That's what I understand from paragraphs 45 and 46.
I believe that's correct.
The properties that are in the administrative stage, and they're listed in footnote 29 of your second witness statement, do I correctly understand from Appendix 2, it was handed out in connection with the claimant's opening and is also found, the claimant's rejoinder on jurisdiction, that the last administrative action for those 9 properties was in each case January 21 of 2009 and consisted of the Spence owner entity objecting to the administrative appraisal?
Could I refer to that exhibit?
Oh, indeed you could. My apologies. It would be Appendix 2, claimant's rejoinder on jurisdiction, or the opening statement. I wonder if someone could just put that in front of Mr. Reddy.
Thank you.
If you are not familiar with this chart, I believe it's the top 9 properties.
Okay. You can ask the question again, please.
Sure. Am I correct that in each case, the last administrative action for those properties was January 21 of the year 2009 and consisted of the Spence entity objecting to the administrative appraisal?
For the top 3 properties, Spence objected as of that date. For the 4th property, it has a slightly different date, April 2nd, 2009. And then for the 5th, 6th, 7th, 8th, and 9th properties, those are not Spence properties. Those are Kofor Holston properties.
Okay, thank you. That's helpful, and my apologies for missing the change to the April 2, 2009 date. So the Spence properties then are the first 4 out of those 9. Is that correct?
Bob Spence personal properties, yes.
Okay. Remaining Spence properties are therefore all in the judicial phase, is that correct?
It's not correct.
Clarify for me, please.
The next several entities, V59, V61A, V61B, V61C, A39, and SPG3 are not in the administrative or the judicial phase. They haven't even started
Right.
an expropriation process.
I sit corrected, thank you. I see in paragraph 47 of your second witness statement that you've commented on a purported unilateral suspension of the expropriation processes for the 9 properties I identified. For the 5 properties for which no action has been taken at all, are you aware of any activity related to expropriation procedures at all, whether marked on this chart or otherwise?
No.
Okay. The actions taken in January and April 2009 for the 4 properties at the top, are you aware of any administrative actions taken subsequent to those dates for those 4 properties?
No.
In your paragraph 47, you describe a unilateral suspension in reliance upon statements made in respondent's counter memorial. Do you, apart from respondent's counter memorial, what, if anything, do you know about the status inside the operative Costa Rican agencies regarding expropriation processes for those 4 properties?
I have no knowledge.
Did you inquire, did you or other people within the Spence organization, as to which you have personal knowledge, inquire of the Costa Rican bodies regarding any further expropriation-related processes for those 4 properties?
No.
Did you instruct a lawyer to inquire?
No, I would expect he'd advise me when a decree of expropriation was issued, and that would be the next step in the process.
Did you, or to your knowledge, anyone within the Spence organization take any other proactive efforts to try to understand the status of the expropriation processes for those 4 properties?
I would ask of my attorney the status, and there would be no change, no information.
Did you discuss with others in the Spence organization process whether it would be unusual for no action to be taken from early 2009 up until the beginning of this arbitration?
Within the Spence organization, I talked to Bob Spence, and it's unusual for us to have these type of delays.
Did you seek in any fashion to discover the reason for the delay?
We would ask our attorney, and he never received an answer.
He never received an answer. Does that mean he inquired on your behalf?
I can't answer whether he inquired or not.
Very good. No additional questions, Mr. Chairman.
Mr. Investor?
Hi, good morning, Mr. Reddy.
Good morning.
Just following up Mark Cantor's arbitrator questions. Could you comment in general terms what were the issues you were interested in discussing with your local lawyers or the lawyers that you visited in terms of purchasing property? I'm interested in the issues you were brought into them. Could you comment on that in general terms?
Okay. We were new to Costa Rica, so I wanted a general understanding of how the Costa Rican real estate worked. They said they had a central registro that registered all the properties and would indicate any liens on the properties or anything of that sort that would affect the title. We were told that our properties extended to the 50-meter line and they were outside the park. That pursuant to the park law, if they ever did want to expropriate us, that we would still enjoy ownership until such time as they expropriated. In the event they expropriated, that we would get full fair market value at that time.
Following my first questions, were you satisfied with the answers, or they suggested when they see the development of things happening to the property, they suggest any actions to be taken?
So I was satisfied with the answers that
Yes,
I own
yes.
privately titled
Yeah,
properties.
just personally, I mean that.
Right.
Yeah, okay.
Yes, I was satisfied.
And did they suggest any actions to be taken for the development of what was going on with the property?
We did get title insurance, which is standard in the United States. I wouldn't tell you it's standard in Costa Rica.
Thank you very much.
Mr. Reddy, just a number of questions from me, and I take it from your response to Mr. Vinuesa, and we've seen in any event your description of your own expertise, but you don't have any expertise in Costa Rican law.
Correct.
So you were relying on the advice that you were getting from your local lawyers or estate agents or others.
Correct.
You testified in response to cross-examination, or perhaps not in response to cross-examination, in response to your direct examination to start off with, that one of the advantages from your commercial perspective of these properties was that they had a clean title and that U.S. purchasers do not like concessions.
That's correct.
In the light of the stamps to which counsel for the respondent has taken you, which indicates the notation in respect of the 1991 law, in some cases the 1991 decree, in some cases the 1995 law, did you have any appreciation that there may have been a risk associated with any onward sale of those properties in respect of potential U.S. purchasers who perhaps did not do quite the due diligence that you did, or perhaps did not quite rely on Costa Rican lawyers, but simply saw the annotation on these stamps?
Could you repeat that again, please?
Was there in your mind at the time any appreciation that purchasers coming after you, those to whom you may have wanted to sell the property, would not have had the same robust confidence that you had in your interpretation of the 1991 decree and the 1995 law?
You know, I don't think I tried to put myself in their mind. It was very clear to us that we were buying private property titled to the 50-meter line, that we maintain full use and enjoyment of that private property, that the park extended seaward. So I had no issue with that. Any buyer would be represented by a Costa Rican attorney and would get their advice and make their own decision.
So it wasn't an issue that you would have addressed yourself at that time?
No.
Your expertise is in financial matters. Is there any sense in your mind that you were getting a discounted purchase price on those properties because of the stamps and the uncertainty that might have been engendered because of those notations?
No.
Was there any appreciation in your mind that you were both assuming a commercial risk and taking a commercial opportunity associated with those notations?
There's risk in buying any property as to its use, but not specifically related to the park, no.
Okay. Thank you very much, Mr. Reddy. Thank you.
Thank you.
Council, I think we've reached 5 minutes past 12. We've been going for an hour and a half. I think, subject to any comments that you each may have, I think the tribunal would be reluctant to proceed with the witness evidence of Mr. Berkowitz at this stage, so we propose to take the lunch break early, if you're in agreement with that. Mr. Alexandrov?
We're in the hands of the tribunal.
Well, then, may I suggest that we break now and reconvene at 1:30.